Hello. So welcome to week 8 of Law 726, the Intellectual Property Survey class for the JDinteractive program. This is Professor Ghosh, and we have with us today as a guest speaker, Professor Marc Greenberg, a professor at Golden Gate Law School in San Francisco, and the founding director of the Intellectual Property Law program. And he'll give us some insights into copyright law practice, as well as on the topic of termination rights, which we're going to talk about in week 8. He is the author of a really great book from the American Bar Association. I hope I don't screw up the title, Mark, but Copyright Termination and Recapture Laws, Good Intentions Gone Awry. Is that correct?
That's correct.
Okay, Mark. Well, thank you for joining us. We really appreciate you taking the time out and giving the students your insights. Would you like to talk a little bit about your own background in education and then your foray into intellectual property and copyright law, with some sense of what advice you'd give to students nowadays?
Sure. I think probably the most important piece of advice that I can give to students who are interested in a career in entertainment law is that there is no path specifically that one follows. Lots of people fall into entertainment law practice accidentally or through friends or colleagues. In my case, the journey was one that I began when I was a college student at Berkeley in the late 1970s. And I had a good friend who, as part of the Cesar Chavez farm workers movement, wow, used to hold concerts in Berkeley at major arenas for Latin jazz and salsa bands. And he was a good friend of mine, and we got to talking, and at one point he asked me if I would be the backstage coordinator, keeping an eye on who got in and who didn't get in to the front to the back gate where the performers came through. So we were well-known performers: Carlos Santana, Flaco Jimenez, all kinds of wonderful people, Tito Puente. And so I worked backstage security, and I was also a bartender for Latin jazz shows. I had a great deal of fun with it, and I got really interested in the music business. And from that initial contact, I took classes in law school in entertainment law and in copyright law, which gave me some preparation. My initial couple of years in practice was strictly a business and corporate practice, as well as a litigation practice. But I had an opportunity about 5 or 6 years in as a young attorney to go to work with an attorney named Ned Hearn, who was kind of a leading light in the entertainment law business in the Bay Area. Ned represented a lot of new age music, including Windham Hill Records, which is a very well-known new age music company. And through Ned, I worked for about 1.5 years on entertainment law cases. I learned a lot about the contract and litigation side of these cases, much of which involves copyright registration, copyright licensing, and in some cases, litigation over copyright infringement. And then I had both the good luck and the bad luck that Ned and his partner decided to stop their practice and go into solo practice, leaving me a bit adrift. But they were kind enough to allow me to take a certain number of clients with me. And so I left their firm with 29 clients, mostly in the music and entertainment business. And from that, built an entertainment law practice in the Bay Area, which grew to a pretty successful rate. And then in 2000, I had been teaching as an adjunct for about 8 years, from 92 to 2000. And in 2000, I was invited to join the faculty of the law school at Golden Gate University, which is an ABA accredited school. I joined the faculty and launched a extensive IP law program. Despite my full-time gig now being as a law professor, I still am involved as an attorney and as an expert witness. And in fact, just last year was an expert witness in a copyright termination case like the ones that we're going to talk about. I got interested in copyright termination along the way And that interest ended up becoming my second book, which I can shamelessly plug. I'm good at shameless plugging. This is the Copyright Termination and Recapture book. And it's published by the ABA and is also available in an online version.
And you've had some really interesting clients. Do you want to talk about some of your clients as well that you've had?
Well, I've had a wide array of clients, and in the entertainment business, probably the two clients that are most familiar to most people. I spent about 4 years in litigation representing the rock band Aerosmith in litigation with with a former manager over a management contract and his share of royalties on the Permanent Vacation album, and also spent time about 6 years representing the actor Wesley Snipes in litigation with New Line Cinema over the motion picture called Blade Trinity. And actually one that I was reminded of reading the case you assigned, I also represented Elmo Shropshire, who came to fame for a song called Grandma Got Run Over by a Reindeer, in litigation with with an ex-wife over who owned the copyright rights in their divorce.
Yeah.
So yeah, it's been an interesting run, and I've had an extensive range of clients in both music, motion pictures, graphic arts, and comic arts.
Yeah, this is interesting. I mean, this is an important point about how broad-ranging entertainment law practice and IP practice can be. You not only have to understand the copyright rules and structures and the policies and procedures. It's a lot of contracts, a lot of basic property law, a lot of business law. I mean, how would you advise students in their course selection? I mean, I think, you know, as you say, they take contract law, but a lot of the contract law they take is not going to touch on entertainment. But a lot of the contract law they'll learn, hopefully, does come up in entertainment law practice.
Yes,
So
it does. I think a solid foundation in contracts is critical. You've really got, and by that foundation, I mean going beyond what you learn in the case book, and getting as much experience as you can as a student in actually writing. Anything that you have, anytime you have an opportunity to draft a contract, that's a valuable skill. And one of the courses that I initiated at Golden Gate, which isn't really offered in very many law schools, is a course in negotiating and drafting entertainment law contracts.
yeah,
Because it's a highly specialized area. One of the other things which I always recommend for students is that they need to read a lot in industry and trade materials so that they're familiar with industry terms, industry trends, and aware of new cases that are being decided, which are often discussed in the entertainment trade press.
yeah. And so, you know, you were fortunate enough to be in California, where I guess most people think about the heart of entertainment law, but there is entertainment law throughout the country, throughout the world, obviously. How would you advise students outside of California? Are there particular parts of the country they should look for? Is this a field that they can develop somewhat anywhere, since they're creative talent pretty much throughout the country?
Well, there are centers. There are areas where a lot of entertainment work is concentrated. New York, obviously, is one such place. Los Angeles is another. Seattle still remains a source of entertainment. Also, the New Orleans area, Nashville, Austin. There are a number of places.
Atlanta.
Yeah, Atlanta's
Yeah.
a very big market. Absolutely. And the law practice in entertainment law varies also. There are mega large firms that handle mostly large production companies, but a lot of the work for small production companies and in private entertainers, individual entertainers, is done in boutique law firms, 2, 4, 5, or 6 lawyers. So law students shouldn't think that unless they can get into a major entertainment law firm, there's no place for them in the field. There's actually a lot of different opportunities. One other area which is not often thought about is government. You can work in the Copyright Office, in handling copyright litigation. You can get involved with working as a legislative aid to some of the senators, say in the Judiciary Committee, where they draft legislation relating to copyright. It's a wide area of enterprise, and there are lots of opportunities.
And there's a lot of stuff happening in some state governments, certainly in the states you mentioned, or the states in which the city's already mentioned. I know
Sure.
New York State every couple of years is considering redrafting their right of publicity legislation, as well as trademarks and other things. Even some state copyright issues come up, obviously, with
once in a while you get state copyright.
Yeah.
Mostly, though, as you note, it's in right of publicity.
Yeah.
It's in basic contract law. There's a lot of employment law also that comes into place, because there are statutes such as in California governing exclusive rights to a performer's services and how long those contracts can last. There's a 7-year rule that you can't tie somebody to an exclusive services contract for more than 7 years. Mm-hmm. So yeah, state law comes into play as well.
And as an attorney, you can also represent clients as an agent, right? Or is that a different type of professional track than being an entertainer's lawyer?
Right. Well, there's really there are 3 areas where lawyers get involved in the entertainment industry. One, obviously, as attorneys, and there are different roles that lawyers play in that context. Lawyers can also be personal managers, mm-hmm. and they can also be talent agents. Mm-hmm. Talent agents involves the booking of live engagements, and talent agency in most states, and certainly in California and New York, is the subject of a separate licensing process. So while you can be a licensed attorney, you do not, by your license as a lawyer, automatically have a right to be a talent agent. Mm-hmm. You have to comply with the talent agency laws, which in California require you to post a financial bond and to maintain an actual office. You can't do it as a virtual office. And there are restrictions on the amount of commission that you can take. Typically, it's 10% for anything other than the very low end of the agency field, which is like a ramp, or I should say runway model contracts, that sort of thing. Because there's so little money involved, agents can charge in California up to 20% of the fee for that kind of work. But generally, they're constrained to a 10% fee.
Yeah, interesting. Well, that's very helpful in terms of giving the kind of the lay of the land for people who are thinking about this field. You know, one thing we can just touch upon a little bit is, you mentioned copyright. We talked a bit about right of publicity as well. Do you find other areas of intellectual property having some play in your practice, or?
Oh, yeah. A lot of work these days is done on various aspects of the digital revolution. So you have, for example, augmented reality programs, virtual reality programs that you get involved in, licensing of rights of publicity, sometimes trade secret gets involved, as well as having a thorough understanding of the big 3: music, copyright, trademark, and patent.
Right, yeah. How about patent? Does patent come up? I think we sometimes mention Michael Jackson's moonwalk patent, whatever that might be, but
I'm not sure about that. There's always been a lot of interest.
I think it's the shoes. I think it's on the shoes, or a version of the shoes.
Okay. Yeah. That would make sense.
Yeah.
Occasionally, patent comes into play in the entertainment context, usually when we're talking about new devices for storage or playback. And so there are patents that come into play there. By and large, the predominant field of law that you work with in the entertainment field is copyright law.
Yeah, fascinating, yeah. Well, good. I think we're ending our discussion of copyright law this week in our class, so this is a good point also to talk about termination, I guess, in many senses of that word. And you've written the book on termination. It's a really great book. I've tried to incorporate it. I want to get the students to buy it as well. I think it's a great book to have on the shelf.
Thank you.
I'll share a link with our class. But we're ending our discussion of copyright with the Baldwin case. We don't need to talk. We can talk specifically about that case, but would you want to give the students another perspective on why we have these rules, and are they things that are unique to the United States? What role do they play in copyright law, and where's the practice? I mean, obviously the practice for termination has boomed in the last decade or so because of the dates, but
Right.
what is
Well,
the
it's
future of that?
it's an interesting subject of the law I've been fascinated by because it deals with an odd thing. Our whole political and social process is geared around private ownership of property. And when it comes to private ownership of property, if you sell somebody your property outright, then it's gone. You no longer have it, the purchaser has it, and you got whatever compensation you got for it. In copyright law, though, we have these odd two laws, sections 203 and 304 of the 1976 Copyright Act, which actually allows a owner of a copyright, someone who created the work, to sell that work to a publishing company or production company. And then after a period of years, depending on which statute, it's a different period of years, the seller can actually get back that which they sold. So it's not a grant for all time. But this all arose out of Congress's concern that performers had no leverage in the bargaining process when they went into deals with publishers and producers. And there's no question that that's true. The artists, particularly in the early stages of their careers, have very little bargaining power or leverage, and then a big production company or publishing company comes along and offers them a record deal, a book deal, whatever the particular rights deal is. This is the golden ticket for them. This is their goal. But the truth of the matter is that because they lack bargaining power and leverage, the deals they get, often the first deal is a terrible deal. It provides very little money. It exercises complete artistic control over their works. So there's no way to avoid that disparity in power at the outset of the contract relationship with an artist as young and just getting started. Congress wanted to address that. And in the 1909 Act, the way they dealt with that was they said, okay, let's create two separate terms for copyright ownership. You'll as the creator, you'll have a first term for 28 years. And then at the end of that 28 years, the term ends and you, the creator, can renew your term, re-register with the Copyright Office, and you get a new 28-year term. What Congress intended for this to do was to give the artist the opportunity to build their career, and by the end of the first term have a more bargaining power, more leverage, and go back and renegotiate with their initial publisher, or for that matter, go to another publisher to and get the benefit of the added fame they had accumulated in the preceding 28 years. That was the theory.
And just to clarify, that's what we're talking under the 1909 Act.
Correct. This is under the 1909 Copyright Act, 2 terms of 28 years.
Yeah.
So Congress structures things like this with the idea that this will give artists, as the proverbial phrase is, a second bite at the apple. Mm-hmm. The problem, of course, is that publishers and publishers' lawyers looked at this and said, well, why don't we just go to the artist and offer them a contract for both terms?
Right.
At the same lousy terms as the original, as the first contract, mm-hmm. which is what they started to do. And so in 1946, there was a case that went all the way up to the U.S. Supreme Court, Fisher versus Whitmark, mm-hmm. in which the Supreme Court was asked, was this legal? Was this essentially a workaround around Congress's intent of having a second term and a second bite at the apple? Was it legal for these production companies to negotiate both terms in the initial contract negotiation?
And to tie back to what we talked about earlier, sorry to interrupt, this is a nice example about how contracts and copyright interact. Right?
Yes, absolutely. Yeah. Yeah. And in fact, that's really the key. I'm glad you said that, because the key to the decision, which was first in the Second Circuit and then affirmed by the Supreme Court in the Fisher v. Whitmark case, was that the artist should have the freedom of contract, the power and the freedom to enter into whatever contracts they wish to, and therefore tying them and saying they could not enter into a new contract to renew the copyright until the beginning of their second term, took away their rights, took away their freedom.
Mm-hmm.
Now, there was a strong dissent in the Second Circuit case, which I frankly agree with. The dissenting judge said, look, it doesn't matter if you have the power of contract if you have no leverage.
Right.
And that was real, and that the whole point of the congressional scheme was to help provide some leverage for the artist. Mm-hmm. Notwithstanding that dissent, the Supreme Court affirmed the case. And so as of 1947, I would say, companies were free. They had a mandate, in fact, from the Supreme Court that they could negotiate away with the artist their rights to the second term. So when we get to 1966 or thereabouts, when Congress begins debating a revision of the Copyright Act, and they spent 10 years doing it until they came up with the Copyright Act of 1976, Congress looked at this and said, well, we need to go back to the drawing board because our first attempt didn't work. The courts frustrated it. Mm-hmm. So they came up with, in the 1976 Copyright Act, a different approach. And the different approach was also mandated by the fact that one of the things they did in the 76 Act, since the two 28-year terms didn't work, those two 28-year terms had created another problem. And the problem that had been created was if artists didn't know that they had to go through a formal renewal process, right, or their heirs didn't know this, they would lose the copyright. It would go into the public domain after the first 28 years because it was not properly renewed. Moreover, to belong to an international copyright community, you had to have a copyright law that had little or no formalities like renewals.
Right.
So Congress in the 76 Act did away with the two 28-year term period and instead went to a life of the author plus 50 years. Now that's great in terms of eliminating the problem of renewals and people losing their rights. But the downside was, remember those crappy contracts you signed when you in your first term? They now lasted for your life plus 50 years.
And 70 years now, right after.
And then with the Copyright Term Extension Act in, I think it was 1999, Congress added another 20 years to that to take it to life plus 70, which is the current law.
Right.
So Congress figured out they had to do something to try to give artists that second bite at the apple again. And so that's where they enacted two laws, the Section 203 and Section 304. Now, these two laws apply to the 1909 Act and to the 1976 Act. You would think, for logic's sake, that they would say the earlier number, 203, would apply to the earlier statute, but no, this is Congress. So 304 applies to the 1909 Act, and 203 applies to post-1976 works created that are governed by the 76 Act. So both of these statutes accomplish the same purpose, but through different means.
Yeah.
And what they accomplish is a right on the part of the author who has transferred their rights to a publishing company to terminate the grant of rights and recapture that copyright for themselves. Right. One of the things that's been most interesting to me in looking at the statute and how it's worked. When I first read the statute, I thought, okay, this is a means by which artists can terminate a grant, get their copyright back, and then go off and do whatever they wanted to with it. In fact, that's not what's happened. And as we've looked at how the law has worked as well as judicial decisions about it, what really it was in Congress's mind was that this was to give artists leverage to renegotiate the deals that they made with the original publisher. Mm-hmm. There are very few instances in which somebody terminates a grant, recaptures the copyright, and goes off on their own and does something with that copyright.
Right.
In almost all of the cases, what ends up happening is there's a further negotiation connected with the litigation, and the lawsuits settle with the parties ending up still working together.
And you sort of see that in the Baldwin case, sort of
you do
multifold, right? Because
yes.
you had an initial renegotiation, and then the case we're reading, it really is wondering what was the impact of that renegotiation.
Well, and also the Baldwin case is a good example of another problem, which was one of these law of unintended consequences scenarios, which is that parties entered into agreements in different time periods.
Right.
And as a consequence, and the Baldwin case is a perfect example of this, courts have to struggle to decide, is this a 304 case or is it a 203 case?
Right.
And
right.
it has, as you saw in the Baldwin case, it has a significant impact on when the copyright term expires and the work goes into the public domain.
Right, right. No, that's why I signed the case. It's kind of a headache case probably to end with, but it's actually kind of an interesting case, even though, Santa Claus seems like it's going to be kind of a happy case and, happy context. But it's funny how entertainment law cases tend to be not that entertaining when you look at them.
One of the things that I tell students all the time is that while there's a certain attraction, glamour, and sexiness about working in the entertainment law business, when you're sitting around in your office at 2 a.m. reading a foreign sub-publishing royalty statement, the romance is gone. And an awful lot of entertainment law work is incredibly complex and requires a tremendous amount of concentration and focus. Yeah. It is not something that I would recommend somebody go into lightly. Right. There are hundreds of millions, if not billions of dollars at stake in many of the contracts that you're involved with. And you're dealing often with works that go back 50, 60, or even 100 years.
Yeah, there are a couple of other points I thought might be worth, since we're here, talking about before we end our discussion. One is, outside of the U.S., how do other countries, let's say in the European Union or specific countries in the European, how do they deal with just the bad deals that artists get into? Do they have more forgiving contract laws than we do in the U.S. or?
I wouldn't say that,
Okay.
although it's an interesting thing, and sometimes it's about the evolution of awareness. Back in the early 1970s, when I was doing some work on international contracts, I was always interested to receive entertainment law contracts from Japanese firms, because the contract would be 3 pages long, and it would begin with language like, "In the spirit of mutual unity, we decide to do these things." And then as Japan became more involved in contemporary entertainment law business, their contracts regrettably dropped all that lovely language and became like a U.S. contract, 40 pages long with a 30-page rider and a 20-page sub-rider. Incredibly complex. But probably the most significant difference between the U.S. and European contracting in the entertainment law field has to do with moral rights.
Yes.
And that's probably the way that under European law we deal with rights of the author. It's not so much viewed as a contract right as it is a moral right to the integrity and to the attribution given to your work, and that gives artists some leverage instead of the termination and recapture laws that we have.
Yeah, so you have droit de suite under moral rights, and we recognize that in the U.S. in some states, New York, California, Louisiana, but it's usually limited. I think it's always limited to the visual artists.
Right,
right.
106A is the only place where we have an overt recognition of rights of integrity and attribution. And as I like to point out, the fine arts world is the smallest of the fields in entertainment and the least lucrative. And so the U.S. granted a limited moral right to that one area that was really a sop to the EU so that we could be allowed to join the Berne Convention. With a wink and a nudge, and we said, well, look here at 106A and fair use and our contract law is all balled together roughly equals moral rights, which it doesn't, but everybody decided we would kind of, with a wink and a nudge, say that this was okay.
Yeah. No, we won't have time to talk about moral rights, unfortunately, in this class, but I'm glad we're able to touch on it, and maybe we can talk about it in the synchronous portion of our meeting with the class. So
sure, that'd be worthwhile.
Talk about that. Just two last points. One is there are exceptions under 203 and 304 for derivative works, right? You want to talk about that a bit and how that figures in terms of the value of these rights and
well, it's an interesting problem, and I can probably best illustrate that with the termination case involving the right to ownership of Superman, because Superman was created initially in the early 1930s, and the grant of rights was done in late 1937. Superman first appeared in April 1938. And so the grant of copyright was to that first issue of Superman in 1938. And then many years later, in 2000, I think it was about 2004, litigation was filed. It was the third of a series of lawsuits, but litigation was filed to terminate and recapture the rights to Superman. The problem for the heirs of the creators, both of whom by then had passed away, was that what they were seeking to recapture would give them the 1938 version of Superman. And since 1938, between 1938 and 2004, DC had made many changes. DC, the publisher, had made many changes to the character, and the 2004 version of Superman was vastly different, including with different powers, a completely different look. Comic art had changed dramatically in that time period. So the conundrum faced by the heirs of the creators of Superman was they would get back the 1938 version of Superman. And because DC had created, under a derivative right, the derivative versions of Superman that now existed, they owned the derivative works.
Right.
And that's part of what encourages the result I mentioned earlier, where the parties end up still doing business with one another even after a termination litigation, because the DC heirs needed to use the updated version of Superman in order to make any money from that product, and DC needed the rights to the underlying version that they built upon in order to make any money from the product. So they were forced into a sort of unholy marriage by the termination litigation, which gave the heirs leverage to get a better deal. And that's how this is really designed to work.
Yeah, it's really interesting how much of this is by design, how much of this is by clever lawyering and clever judging, but it's a really interesting system. That's what makes termination rights such a fascinating area. In terms of practice, given the timing within the statutes, we started seeing a bunch of legal work in termination rights, I think in the 1990s, certainly in the 2000s.
Yes.
And it's would you describe that as sort of the high point of this, or is it now a standard part of practice, or how is it? How does this area of practice over termination rights, how does that continue in the future?
Well, it's an interesting area. There are still a lot of cases coming up because of the different timing involved. I mean, the law's been in existence since 1976 and went into effect January 1, 1978 with the copyright law. And it took about 30 years or so for the first, actually 35 years for the first 203 cases to start showing up. The wave of cases we had in the 90s were mostly 304 cases under the 1909 Act. It was rumored to have been a much bigger area of practice than it's turned out to be. And I think a lot of the reason for that is that there are many traps for the unwary attorney or claimant. It's a highly complex field. As the court in the case you assigned references it, it's a thicket. And it's very easy for lawyers to make mistakes. There have been some classic mistakes made in some well-known and well-publicized cases. And I think that's led people to be a little bit more cautious. There's also one huge factor that's made it very difficult to do these cases effectively, and that is that Congress allowed a massive exception in the law, which is that if a work was done as a work for hire under the Copyright Act, you can't terminate the rights. Your termination right is extinguished if it's a work for hire, because if you never owned it to begin with, you have no right to terminate. So as a consequence, every case that's been filed in any major work of creative effort has been met with a response from the publishing company or production company, oh, this was done as a work for hire, and therefore you have no rights. Yeah. And this was the battle that Marvel dealt with the Kirby estate. Famous artist Jack Kirby, creator of the Avengers, Silver Surfer, and so on, battled unsuccessfully for a while, and it was only the threat of a Supreme Court case that might have changed a bit of that law that they were able to end up with a negotiated settlement. Yeah, but work for hire is the first line of defense that most production companies use now, because that exception is baked into the law.
And that's a nice review of work made for hire that we talked about 2 weeks ago. So this all fits together. So thank you again, Mark. This has been really helpful. I think it's been really something that the students benefit from, and I've benefited from. Do you have any final words of encouragement? No discouraging words, please. But whatever words you'd like to end with would be appreciated.
Well, thank you, Shuba. I appreciate this opportunity, and I want to encourage the students in your class to consider the breadth of entertainment law, the scope of it, particularly in all of the new technology opportunities that you have, and think about this as a field worth going into, because I find it endlessly fascinating, and have been and continue to be engaged in this for well over 40 years. So I think you can make a real career that's both intellectually satisfying as well as financially remunerative.
Wonderful. Well, thank you again, and have a great day.
Thank you.
Bye.